Okay, so moving on then from where we were previously, we're going to be looking now at interests in land. So moving on from estates in land, looking at what we discussed previously as the types of hold in land, so your ability to stay on the land, as in were you freely holding the land, you could sell it and pass it on. We recognise that as fee simple, absolute and possession, section 11A. Or were you holding the land under a lease, so therefore a temporary period of time or a term of years, absolute, under section 11B of the LPA. So we're now moving further forward than that. So we're looking at people that can come onto the land and or restrict land use because they have an interest or some other form of attachment to the land. So what we're going to do is just recap what I've done very briefly there a moment ago, looking at estates in land and starting to think about these other people who can interfere with my hold or my use of my land. We'll also have to then consider how that person could have protected their hold on the land or their attachment to the land. The best form of hold or the best form of attachment always being legal. It's the most dominant form of recognition of rights, obviously, and requires a certain level of paperwork and evidentiary requirements. Anything after that would be looking at fairness or what would be right or appropriate or morally correct, and that would be an equitable interest that has a lesser evidentiary requirement. So when we're thinking as land lawyers about the difference between law and equity, primarily that situation boils down to us requiring certain forms of paperwork so that we can identify that agreement and how attached and affixed it becomes to the land itself. So just a quick recap, as we looked at section 1.1 of the Law of Property Act 1925, I took you online, we looked at the statutes previously. There were only two forms of legal estates, what we would previously have recognised as ownership or freehold, if we were escalating the language slightly, becomes the fee simple absolute in possession under section 11A. So I absolutely have the right to possess it. I can do what I want with that. I can sell it, I can pass it on to my children in return for a simple fee, or that idea that the fee simple means that I can return it to others, pass it down through the generations. So that would be what we would have recognised as ownership, and then out of that ownership I can carve one other form of legal estate, that being the term of years absolute. So I can obviously create a tenancy, I can put a leasehold in over my own land, allowing a tenant to be on the land for a specific time period. So that's my most dominant hold, potentially, as a form of legal estate that I will have created. But hopefully from the exercises we did in the seminar last week, the introductory seminar even, you'll understand that there are these other holds and attachments to the land that are just as dominant, especially if we're looking at the bank. So that's the situation we're about to head into now, of looking at these other parties that can say that they have a right over the land itself. As we should know as well, touching on it briefly and primarily covering it in the next lecture, the formalities for making that situation legal, for enabling that legal estate to be fully recognised by the evidentiary requirement we would require under section 52 of the Law of Property Act 1925, a deed to be made, and I will look at that with you in more detail whenever we're doing formalities. So that is the evidentiary requirement. It could be capable of being legal, but it will only become legal once it has the right document affixed to it. Moving on then from there, we're looking at other people's ability to use or attach themselves in some way as an interested party or a vested party in my land. Remembering that all of this has a promissory aspect to it, but we as land lawyers ideally are looking for evidence. We're looking for this to become proprietary rather than personal. In doing so, it affixes and attaches itself to the land because we're thinking about the land as a remedy and not money like there is in other areas of law. So we're looking at how to recognize these people who say they have some sort of interest or attachment or ability to restrict our use of our land. And primarily then from there, they say they have that relationship to the land. We'll be looking for a piece of paper to evidence that usually. And afterwards, our next phase, once we get through these few weeks, the following time we'll spend together, we'll be looking at how that interest or estate affixes and attaches at land registry. So how do we tell the world at large that that's what we've got, that's the hold over land that we have. So as you'll see in the left box there, you've got an interest in land that is usually carved out, created or granted by the estate owner themselves over land. So that will be my wanting to go to the bank and take out borrow money in return for the mortgage on the property. So that will allow me to have the money I need to buy the property, but it will also allow the bank to have an interest in my land. But I'll have given them that interest, I'll have given them that permission. What it means then is that if you look across to the right, we can see, if we're thinking about it going across horizontally, it's capable then of binding anybody who comes to buy the land after that. So somebody who buys the land has to make sure that I'm free of that interest or takes the land with it. So say for example I've granted a right of way across my land. If it's all documented appropriately, evidentiary requirement, and it's affixed and attached to the land at land registry, then the person who's coming across to buy the land can see it. They will know of its existence. Their solicitor, when they're buying or the land is being conveyed, will be able to articulate and identify what burdens that land comes with, and it will bind them. And also then vertically it benefits somebody else. It will benefit the party to whom I have given that interest. So obviously it benefits the person who I've allowed to have the right of way. If it benefits the bank who I've given 90% of my property to. It's in their interest, obviously, to hold that right over my land in some way, and I will have given it to them. It will benefit them and it will bind to the land, because all land remedies bind to the land, and then therefore when I'm passing it down to my children or I'm selling it on to others, it will come as a right, or it will come as a burden towards the person who's buying it, and still be a right that the other party benefited from. Which means that when the person's coming along to buy the land, they need to be able to know that these people exist and then start the process of how to get rid of them if that's what they want to do. Otherwise, they're buying encumbered land. So if they don't want to buy land that somebody's going to wander across, they're going to have to investigate how to extinguish that easement, how to get rid of that party so that it doesn't bind them in the future. Specifically so with covenants, if you're buying a piece of land that is restricted as to how it can be used, it's going to really diminish its market value. So if you can see that at land registry when you're purchasing it, you can make a decision as to whether that restriction is okay with you, or you can make the steps that you'd need to make to have somebody remove it so that it doesn't fetter. If it doesn't make sense anymore, if it's no longer got any rationale behind it, you may be able to apply for it to be extinguished or to negotiate with parties to have it removed. But if without that knowledge, you can't do that. So we'll see if you're thinking about me as owning the land in the middle, and then these parties externally to me where I will have potentially given them rights over my land. So I'm in the middle and I have these interests or rights that others may hold. So if I'm the owner, if we start at the top, that's probably the easiest. So the estate owner moving upwards can have created an easement. They can have allowed somebody to have access to park or to store or to walk, and that will be binding upon them. Covenants, they may have covenanted or promised with somebody that the property wouldn't be used in a certain way, and that can be enforced and attached to the land and come with the land when somebody wants to buy it. The mortgage, I will have given the hold in the property over to the bank in return for money. And obviously, in order to be able to sell the property on, I have to be able to satisfy the bank and repay the money that I borrowed for them so that they can take that mortgage away. They can remove that restriction from the property and allow it to be sold. So they will have to be satisfied that I can clear that debt before sale will happen. Estate contracts are a promise from me to sell the property on to somebody else. So say for example I have 4 or 5 children, I might make a promise with one of my children that if I decide to sell the property, I will sell it to one of them, and that will give them a commitment or a promise from me, a guarantee. It's of no value to anybody unless, as in property law, it's written down, except for 2 key exceptions, which we will look at together when we're looking at formalities. But mostly, as property lawyers, we're looking for evidence of this. So if I promise to sell my property, I make a contract to pass the estate, effectively, the fee simple absolute in possession. I'm contracting or promising with somebody to pass on estate to them for a certain price. Then that should be evidenced and written down. It's an interest in land I will have created. It's not an actual sale. I haven't transferred the property to them, but I have contracted or promised them the sale price. So if they want to have that as a hold over me, they can protect it. Beneficiary's interest under a trust is that typical person meets person, moves in together, puts in some money or pays some bills, raises a family, whatever. They will have a beneficial interest under a trust. It can also be where a parent helps a child or puts money in, etc. So that will be an interest that has been created in the estate for their benefit. The other one, the final one, the landlord's right of entry, isn't an interest I'll have created over my estate as a freeholder. It's an interest that is created over the estate of the term of years absolute. So remember, we can have 2 forms of estate. We can have fee simple absolute in possession or freehold, or we can have a term of years absolute or a leasehold. That landlord's right of entry is actually an interest over the leasehold. So that's the landlord saying, basically the freeholder, saying that the term of years absolute is restricted in some way. Their ability to absolutely use it as if it's their own is restricted by the landlord's ability to go in there and inspect and or to take possession if there's non-payment or breach of contract. So that is an enforceable interest that a landlord should enter, should have a piece of paper for, and should enter against the estate owner at land registry. So those are the main forms of interests that you will come across as property lawyers. It's then important, because we know what the legal estates are, we have to be able to articulate and identify whether something as an interest is legal or equitable. As I've said, the reason that matters primarily for us is because we're usually then looking for a different piece of paper. It really sets what our evidentiary requirement is for that interest. It dictates or mandates what the person then needs to do to protect their interest. So how do we determine if an interest is legal or equitable? Well, if we think about that and we know how carefully legislated for land law is, it should be fairly obvious that we've already been told in one place what legal estate means. Bearing in mind, I've told you that the Law of Property Act is a really good piece of legislation as property lawyers for us to find our definitions and definers. Then it's fairly obvious that we will have legal interests set out within that legislation as well. So section 1.1 deals with legal estate, 1.1a being fee simple absolute in possession, 1.1b being term of years absolute. Section 1.2 deals with legal interests. So only the 5 things listed in section 1.2 are capable ever of being legal. Nothing else will ever be capable of being legal. Even if you put a deed on it, it will not become legal. It's got to be listed within section 1.2 and then have a deed in order to be legal. So that's what that says there. It might have been capable of being legal, but until you put the deed on it, it doesn't actually become legal. I'm trying to think of an analogy there, but if I'm thinking if I cook some beef and carrots and onions and I put them in a bowl or a tin and I serve them up to you as minced beef, carrots and onions in a gravy, that's all that dish is. It's capable of becoming a shepherd's pie or a cottage pie, but it won't unless I put the potato on top. Cheese if you like cheese as well. I'm quite a fan of the cheese on top too personally, but it won't become a cottage pie or a shepherd's pie without that potato on top and going back in the oven and turning into a cottage pie or a shepherd's pie. It was capable of being a pie, it just didn't have the final requirements put on there in order to fully make it a pie. So sorry, that's an overly simplistic way of looking at it. It's all that could come to my head in that particular moment. But it's important for you to understand that those 5 things that we're going to look at in a moment are capable of being legal, but they really won't ever be legal unless they have been protected with the right document, which in this situation is a deed under section 52. So the legal interests that are listed under section 1.2 are coming up in a second, and they are the only, so this is the actual phraseology of section 1.2, and it states that the only interests or charges in or over land which are ever obviously capable of subsisting or being conveyed or created at law. So the only ones capable of being legal are section 1.2a, an easement. I won't discuss the rest with you right this second, but let's just take it as an easement. A rent charge, which you will not need to ever cover in this module. It's a very old-fashioned way of holding on to land that we don't look at any longer. A charge by way of legal mortgage, so that's the bank's first mortgage on the property in return for money, a legal mortgage. Any other similar charge would then be any future mortgages. So if the bank lent more money on the same property, that would be another charge. And rights of entry exercisable over a legal term of years absolute. And that's those landlords' rights of entry over a tenancy that we discussed a few moments ago. Those are the only interests that are ever capable of being legal. An easement, we'll talk about the rest of that sentence in a moment. So basically the rights of way, storage, access, air flow, light flow, water flow, etc. that we looked at previously. A rent charge, which you're never going to have to look at a legal mortgage, which we'll definitely have to look at, a second mortgage, which may come up, and landlord's right of entry over a term of years absolute. So landlord's right of entry over a tenancy. So in every scenario where you see a landlord, a freeholder and a leaseholder, you should be thinking about the landlord's right of entry coming into effect as well. Anytime you see a bank, you are definitely going to see a mortgage, at least one mortgage. The top one, easement, would be only capable of being legal if it's sufficiently definite in nature. So all of those phrases basically mean, does it look like it's freely given as if it was an owner? So equivalent to an estate in fee simple absolute in possession. Does it look like an ownership? Does it look like it's yours free to use whenever you want? You can sell it, you can give it to your kids, you can pass it on, it's just yours to have. Or a term of years absolute would be, is it time restricted? Are you able to do it for 6 months, 12 months, 3 years, 5 years? Is it an easement that equates to that sort of hold of land? If it's an easement for the winter or the summer or when it's raining, whenever you need to get to church, something like that that's vague, it might not be capable of being legal according to this definition. So when we're looking at easements, we have to look at how they're given. Are they given freely or are they given in a time period? That way it could be capable of being legal if it then has the right document on top. Okay, so we're going to do work on that in seminars. If you feel confused, that's something we can clear up together very easily. So when the right would then be legal would be that it's listed in section 1.1. So for us, the two legal estates, fee simple absolute in possession or term of years absolute, 2 of them. Or section 1.2, 5 of them. Easement, rent charge, not worrying about it. First mortgage, second mortgage or subsequent mortgage, and landlord's right of entry, those 5. And then it has the correct documentation on it, i.e. a deed under section 52 of the Law of Property Act 1925. That would be the only way that you would have something recognisably legal in the eyes of property law. It doesn't mean that nothing else exists, it just means that as property lawyers, evidentiary requirements would mean that that's what it would have to have, and that's what we'd be looking for. If it's not that, we have to progress and see what's next. What's next is that under section 1.3, everything else becomes equitable. So any form of other estate, like the life estate or the fee tail, or anything else that isn't a landlord, a bank, or wandering, then those types of interests or holds over land are going to always be equitable. So if we're thinking about what that means for us, if they're not in 1.1, so 2 of the legal estates, they're not in 1.2, 5 legal interests, then they're definitely going to be equitable. However, if they were in 1.1 or 1.2, and they weren't made by deed, you didn't put the mashed potato on top of the mince and onions, it's not going to be a pie and they're not going to be legal. They're going to become equitable. They weren't protected with the right document, therefore they didn't become legal. Okay, again, we're going to do lots and lots of work on this together in class, so if you feel out of your depth, don't worry, we will work through it together. All that means is it's a process of elimination, really. You get your 2 legal estates under section 1.1 of the Law of Property Act, fee simple absolute in possession and term of years absolute. You get your 5 legal interests under section 1.2, easement, rent charge, first mortgage, second mortgage, and right of entry. Everything else then becomes equitable. What we mean, therefore, by the everything else aspect would be if you're the freeholder in the middle, you may have bought that property with someone else's help. So up top, you may have the interest of a beneficiary under a trust. Obviously, that's going to be equitable. Restrictive covenants aren't in 1.1 or 1.2, so they're only ever going to be capable of being equitable. So a restrictive covenant can only ever become equitable. It's never going to be legal. Easements that either weren't freely given forever to do what you like with, or for a fixed period of time, or which didn't have a deed, those will be an equitable easement, equitable interest under section 1.3. And the estate contract, the promise for me to sell land to you for a certain price, that will be also equitable. That will be an equitable interest that has a different evidentiary requirement. So those are the forms of equitable interests that are available and possible under land. So just to sum up, we've looked at the LPA a number of times and we're going to carry on doing that together. Under section 1.1, we have those two legal estates. If you think of them in lay terms, you've got ownership and tenancy. But we now recognise them as the fee simple absolute in possession and the term of years absolute, section 1.1a and section 1.1b. Under section 1.2, we've been given 5 legal interests. The easements one is the most difficult because it's got other words added to it. It's not just easements. It's easements that are freely given or easements that are time dependent, like 6 months or a year. Those things are capable of being legal, 2 and 5. Everything else becomes equitable. So under section 52, if they are legal, either an estate or an interest, we would need a deed. What a deed is, what a deed looks like, how to comply with that evidentiary requirement, we're going to look at in the next lecture. Also, we'll be thinking about what equitable interests require in an evidentiary capacity, what that means, and what we should comply with. So what I want you to do in preparation for the next lecture would be to start to think about this in relation to scenarios. We've got some coming up on the next lecture. You're also being asked for the seminar next week, so the seminar that follows, seminars 3 and 4, you're being asked to create your own plots of land. So you're being asked to draw your own plots of land with some of these people on there. So you're not just embroiling yourself in the language usage of the Law of Property Act 1925. You're also having to think about what this means in reality to real people. So you've been asked to draw plots of land that identify legal estates, that identify legal interests. And I'll be asking you to explain that stuff to me. We might draw one up on the board together, etc. For our online seminar, I ideally would like you to send them to me afterwards so that I can observe and comment on them. But we're also going to be giving you scenarios, and not just text scenarios like you're used to reading through. We're going to give you visual scenarios where you see people, you see land, and you start to get to grip with what this means and what sort of logistics you're looking at. The other thing I want to do with you and share with you is a document that looks at this as an approach that we run through boxes with, but that's quite long-winded, and I would need you to keep a patience level with that because it can appear very daunting. So I'll run through that with you as well. But primarily, what I need you to grasp fully from today would be these two slides. So thinking about when a right is legal versus when a right is equitable. Those are probably the two most important slides on this whole lecture. This notion of it's not enough that it's in section 1.1 and section 1.2, but that now where we're headed next is we're going to think as land lawyers what the documentary requirement is for that. How do I evidence that hold in land? How do I say to somebody and show the world at large that I have that hold over them? Versus this equitable notion that if it's not there, it can't be legal. It's always going to be equitable. And equitable means that it's more about fairness, morality, and right. If you think about those things we saw in this slide, all of these are promise-based. I promise you can live with me and everything will be okay. I promise I won't use the land in that way for a restrictive covenant. I promise you can access this or park your car there. I promise that you can I will sell the land to you for that price. So equity is about fairness, morality, and what would be right or true or fair in that situation. It looks at those relationships, but it doesn't just recognize them as personal. In property law, we are still attaching and affixing to them to the land, just not with the same document. If we look at these ones, however, they aren't, apart from easement, really all that related to promissory situations. They're related to financial situations and ways to restrict and fetter the land because of financial interests in it. From the bottom, you're looking at this landlord's right of entry as an ability to fetter your tenant. So it's protecting my financial asset as a landlord. It's helping me regain access to my land in return for the return of the property itself to me. If the tenant has defaulted, it allows me to inspect to see if it's being maintained. And it's definitely recognizing the financial asset of the land. So we've got then legal mortgage and a charge. These are obviously protecting of the bank, so they're again protecting the financial asset of the land itself. They're protecting the financial nature of the relationship. They're protecting the bank because it's a secured loan in return for the property. And then we've got a rent charge, which was a very archaic way of binding land, even when it was later going to be sold off. It was able to give an income to landowners in return for releasing land for development. And there were small nominal payments which increased over time. So that's something that is no longer used, is no longer relevant, but is again not promissory. It's based upon recognizing the land as an asset. So 4 out of 5 of the legal protection mechanisms or the legal interests in land are purely financial in nature, and all of the equitable interests in land are promissory in nature. They're looking at relationships and things said between parties. So that's where this stuff matters. As land lawyers in law, we're recognizing that those 2 and 5 are capable of being legal and require the right document. Everything else, or if it's not been made by the right document, will therefore become equitable. So in the next class, what we're going to do is we're going to look at what that everything else means in terms of evidentiary requirements. So how do I then formalise or documentise my equitable title or hold in the land? And we're going to play as well. We'll look at some scenarios where we can identify estates and interests and start to think about law and equity. Okay, so thank you very much for your attention and time. The next lecture will probably be a little bit longer because there's more to cover, but this is very important rudimentary stuff that you will see and that we've got to build on a foundation of. Thank you.